Alex here with another video on high conflict child custody. This video is going to be on discovery, and that's going to encompass exhibits, evidence, subpoenas, and other mechanisms. There's a formal discovery process, at least in Nevada. I'm not sure if all the other states have this. I actually didn't go through the formal process. I went through the post-judgment discovery process, which is a lot more restrictive and complicated. But if you're going through a high conflict child custody matter and you're representing yourself and you don't settle your case, there's going to be something called a case management conference. And at that conference, at least in Nevada, other states, they might not have this and it might be called something else. And what's going to happen at the case management conference is the court is going to figure out what discovery tools are going to be available, how many days, the deadlines between the days, all of the restrictions on discovery are going to be applied on that day, and you're going to find out a lot of information that you're not going to understand unless you know what it is going in. You're going to just be completely clueless as to what's going on. But the court's going to be setting this process up. It's going to say when discovery starts, when it ends, and you need to use this process and you need to be aware of how to respond during this process so that you don't end up totally screwed, for lack of a better phrase, at your hearing. Because if you don't comply with discovery, you could be sanctioned, and if you don't go through discovery, you're going in there with both hands and a foot tied behind your back. So to understand what discovery is basically the court has come to the determination that you are not settling, you're going forward to trial. And unlike everything you've seen on TV with Judge Judy or the People's Court, you don't just show up and just flap your gums at trial and randomly show evidence. You have to obtain all of the evidence before trial and exchange it with your ex. And the process for doing so is highly technical and procedural. And you're going to go in there, at least if you know what you're doing, you're going to go in there with a thorough understanding of what your ex is going to bring up and what you're going to need to do to defend it. If you don't understand the discovery process and you just ignore it, then you're going to go in there clueless, and if they have an attorney, they're going to have a huge advantage. So the first thing you need to do is look up the rules of civil procedure. Well, the first thing you need to do is read the court's order on discovery so that you know what you can do, when you can do it, and how much of what you're trying to do you can do, because that's going to outline all of the details. The different tools, they have different names. In Nevada, and I'm sure that this is consistent across the United States, there's 3 different things. One of them is called request for production of documents and things. You need to figure out what that is according to your state, and the power of that request and how it works. In Nevada, you just outline a big giant list of the documents and things that you're demanding your ex produce to you, and you send it to her attorney or to her. The second thing is interrogatories. It's a list of questions, open-ended questions, that your ex has to answer before trial. So this is useful. You can get your ex to answer a lot of questions that are relevant to your custody matter before trial, and you can use those at the trial, or you can it kind of gives you an idea of what direction to go into, because those answers that she gives are going to be under oath. And the third one is requests for admissions. These are questions, but they're not open-ended. This is a list of questions that your ex has to admit or deny. She cannot answer them in an open-ended fashion. So you're going to be able to send your ex these different tools, and you're going to be able to obtain the documentation you need, the questions you need answered, and the admissions that you need admitted or denied, so that you can figure out how to go forward. When you receive these, you need to comply, because if you don't, you could find yourself horribly straitjacketed, especially if you do not answer the requests for admissions. At least in Nevada, the failure to respond to requests for admissions is automatically considered, the court will consider that all of the questions are admitted to. So that's a huge, huge, huge sanction if you don't respond to those. The other thing that you can do is issue subpoenas. Well, subpoena ducus tecums, to be more precise. The subpoena, a regular old subpoena, is just asking not asking, it's commanding someone to show up and testify in court. That's what a regular subpoena does. When you issue a subpoena, like I've mentioned with everything else, you better read the court rules, because if you don't comply with the rules, the subpoena can be ignored. Most importantly is that you pay the fee. You have to give them a check. In Nevada, at least, you have to give them a check, and I believe it's like $26 plus some kind of mileage. And then that's only if it's a lay witness. If it's an expert witness, you have to go through an even more complicated process, and usually you have to pay a lot more money for an expert. But sometimes you need one. If you're going to go in and try to present testimony against your ex regarding her mental health, and you don't have an expert, you don't know what way that's going to go. I mean, usually when you don't have an expert, the court will try to question them and see if they can figure out what's going on. But some judges don't want to do that, and if they don't, then you're not going to get anywhere. Going back to what I mentioned, subpoenas ducus tecums, it's almost the same thing as a request for production of documents, but instead of issuing it to your ex, you're issuing it to some third party that has documentation that you need for your court system, or your court case. So, for example, if you need something from like a doctor and you can't get it for whatever reason because maybe your ex doesn't have the documentation or something, you can issue a subpoena ducus tecum to that doctor, and then that doctor would produce the documents to you. So I'm just clarifying, a ducus tecum is you're asking for some kind of documentation or something. If you need the doctor to actually show up and testify also, then that would just be a regular old subpoena. But again, make sure you figure out whether or not you need them to provide expert testimony. What that is it's an opinion that has merit because of their profession and their experience. If you just need somebody to testify as to what they see or hear, even though they're a professional like a doctor, if you just need them to testify as to something that they heard or saw with just their regular old eyes, then you can just subpoena them as a lay witness and you don't have to go through the complex process. But of course, when they show up in court, you can't expect them to give any expert opinion to the court. So this is the process. The formal process for discovery is going to go through what I mentioned, the case management conference. In Nevada, everyone goes through it. Everyone gets to go through it unless they settle. If you settle your case, or even if you don't, if you go through the trial and your case, the judge comes to a decision, either way, once your case ends, whether it's through settlement or through a trial, if you go back to court on something called a post-judgment matter, so you're trying to change custody, the court has ordered custody and you want to change it now a year later, then you don't get to go through this automatically, at least not in Nevada. Maybe other states will allow you to, but not in Nevada. When you file a motion and you get a hearing on your motion to modify custody, if you need discovery again, then you need to ask the court in Nevada to reopen discovery. And it's usually, unless you have a really good reason, it's usually not going to be granted. And even if you have a good reason, it's going to be granted in a very restricted sense. Like they may only allow you to do one or two things to prove the allegations in your motion. A few other pieces of advice. My opinion is you shouldn't ask your ex for documents that you could obtain on your own. If you have some kind of evidence that you have a way that you can get on your own, it might feel good to force them to jump through hoops and produce things for the court or for you just because you're pissed off or angry. But I mean, these little things, they can backfire. I mean, my ex was constantly trying to say that I was harassing her because I was constantly bringing motions before the court. So in my opinion, my practice was to only demand what I absolutely needed from her. Because then when I went to court, I could articulate to the judge, I had to ask for this because I had no other way of getting it. And look at these 2 or 3 other things that I could have asked for, but I found another way to get. The other thing is, do ask questions in interrogatories, requests for admissions. Do ask questions that you already know the answer to, because even though you know the answer to the question, if you feel that your ex might change her story, or if one of your arguments in court is going to be based heavily on that assumption, the last thing you want is the rug pulled out from under you. All of a sudden your ex says that never happened, and you were going in there thinking that of course that happened, I saw that. Well, the discovery process is a great way to get that clarified before court, is get those things admitted to, get those interrogatories answered, just so that you can go in there with your theory and know that certain things she's already admitted to. She can't change her story in court now. So with that being said, there's one more thing, evidence and exhibits. You have to understand the difference between these two things. When you're filing a motion with the court, or when you are trying to get the court to hear you on a particular issue, you can bring exhibits. What an exhibit is you staple it to your motion or you submit it ahead of time, and the court will look at it and consider whether or not this exhibit gives you a prima facie case. A prima facie means at first glance, it looks like you might be right. You can use exhibits like letters from psychologists and doctors, notes and stuff like that to get a hearing, to show the court that there is something here to be looked at. But once you get your hearing, your evidentiary hearing, you can't use those again. Those can only be used to build a prima facie, at first glance, case against your ex. So these letters, Your Honor, show that there may be a problem. Once you actually are in court and that evidentiary hearing is running, you can't bring those letters up again. You need the person who wrote the letter. You need the psychologist. You need the doctor. When I filed my motion to modify custody because my ex was dentally neglecting my son, I used pictures and documentation in my motion to get the hearing. But once the hearing came, I had to get the dentist, I had to get the dental hygienist in the courtroom. This is something that I cannot stress and underline enough. So many people go into court with these documents, and sometimes you'll get a good judge who really cares about the kids. I mean, I'm not saying that the other ones don't. They may be busy, or they may be afraid of getting their decision reversed on appeal. And the judge may consider that because your ex didn't object to it because she didn't have an attorney. Or if she had an attorney, the judge may just question your ex. She may look at the letter that you brought and question your ex on some of the things in that letter and use your ex's testimony against her in that fashion. There's ways that judges can sort of get around this restriction. But if you're going in there and you want to win your child custody dispute, you don't want to take these risks. You don't want to rely on hoping that your judge cares enough to bend over backward to try to get your ex to admit something in the note or letter you brought, in the police report, even the police reports. I had a friend that was trying to get help. She filed her motion, and I said, you can use those police reports to get a hearing, but once you go to court, you need to get the cops in the room. And she did that. She put the police reports in. She got her hearing. She went to court. She got the cops in the courtroom. She won. So don't take these risks. Understand the difference between an exhibit, which is just a piece of paper or a picture just stapled to a motion, and evidence, which is actually getting the testimony that you need. Testimony is evidence. A lot of people think evidence is like a video or something like that. A witness speaking in the courtroom is considered evidence because the witness is there. And the reason for this is that the witness can be cross-examined. If you bring in a letter to court from a doctor or a psychologist, the judge can't cross-examine that letter, and your ex's attorney can't cross-examine that letter. One of the things that I see a lot is a psychologist will do a letter for somebody because they asked for one. They'll take it to court, they'll present it. And the issue is the psychologist might not know everything that's going on. So this actually happened in that same case. Not only did my friend bring the police to the courtroom, because her ex also filed a letter from his psychologist. She subpoenaed his psychologist, and he appeared. And she was able to question him. And the psychologist found out things he didn't even know from his own patient. And when he found those out in the courtroom, he said, I have to take back everything in my letter now. I didn't know this was going on. And so this is why it's so important to get the person in the courtroom. When you there are some states that have exceptions in certain areas of the law. So for example, in Nevada, there's other areas where, like, if CPS takes your kids away and you go to court on a permanency hearing, they can consider letters, or they consider hearsay from, for example, the court-appointed special advocate. But these exceptions are rare, and in Nevada, as I mentioned, that they're not even in an ordinary child custody matter. So you could check in to see if in your state you can bring letters and use them as evidence. I don't think that it's a likelihood. I don't think it's very likely because it's such an important matter. I mean, deciding where your kids are going to stay. But even if it's something that your ex can do, for example, say you're in a state where your ex can use letters against you, even if that's perfectly legal, it doesn't stop you from subpoenaing that person. So that's something that I would recommend you do. If you see your ex is using a letter against you, and you're worried that the judge is going to use that letter against you, even though it's not the truth or whatever, you can subpoena that witness and get them into the courtroom, and you can cross-examine them that way. So again, this is a highly complex issue for people who don't understand how the legal process works, because a lot of people watch Judge Judy or Marilyn Milian, or a lot of people have gone to small claims court, and you just really show up and bring everything there on that day, and you just talk and see what happens. It's not how it works. Pay close attention to the discovery process in your court system. If you're going through it, use it and respond to it appropriately. And best of luck. That's the end of this video.